Okay, abusia ba makwa ba so edeba Ghana politics abeni so abusia yembonra yensemu high court ruling on Kpandai seat oka say after 7 days on to me appear in parliament abusia Sisiano Kpandai NPP MP Sisiano parliament party obetune na yesi o masa ye refusing on say memani 29 ANC parliament, and lo and behold, parliament were to me and 29 ANC were NDC majority chief whip at the Honsem about to Yamote say, or more man pine that say obe 29 at the AC parliament, and court and also a ruling say as a rerun of elections. So, Mammy, na young conkuti and Sema so unsubscribe here. Subscribe it, like it, now share my front so and sa into me and can be Ghana politics avenue so
You went to court with 41. The court ruled on all 152.
You see, John Daku is a brother, my roommate. We read law together. We wrote exams together, passed them together, qualified together, and practiced. We were not practicing in the same place, but we are brothers in the law, and his law is sound. But I am scandalized by the kind of reasoning is oozing tonight. Who says that when you go to court and you make allegation regarding some percentage of irregular, or you make an allegation of irregularities, whether you cannot pray the court that based on those irregularities, the entirety of the process should be invalidated? Who says that you can't do that? Was that not the gravamen of the 2012 Akuffo petition? And let me tell you, the first issue set down by the court in this matter, which was part of the memorandum of issues filed by the petitioner as well as the memorandum of issues filed by the respondents, which the court adopted and set down for determination in this matter, was whether or not the irregularities and the inconsistencies contained in Form 8A, Regulation 32.7 and 39.2, that is the statement of suppose for the office of Member of Parliament, pink sheet, for 41 polling stations out of a total of 152 polling stations in the Kpandai constituency have so extensively prevailed and have reasonably affected the results of the elections held in the Kpandai constituency on 7th December.
So what you just read, that was a point I was looking for to ask my question. So it went beyond just 41.
Yes,
whether
you are saying
that affects
you are saying the irregularities with the 41 polling stations. If the court comes to the determination that the irregularities regarding the 41 are so extensive that they taint the entirety of the 152 polling
stations, on that.
The court should make a determination. And this was one of the findings of fact that the court came. So how can a lawyer say that you went to court, you didn't ask specifically for this, and so the court erred in granting? Meanwhile, this was the issue. Evidence was led. You had to see the video footage. The Electoral Commission took the stand. They were cross-examined. The first respondent, he took the stand. He was cross-examined. So for anybody to say that the court erred, he should go and read Afenyo Markin versus the Speaker. Just a year ago. About 6 or 7 page court ruling. You should go and read how many pages contained the affidavit submitted by Afenyo Markin to the court before the court came to a test ruling or order in less than 1 page of the entire ruling. You should go and read. This attempt to bastardize judges, we won't do that. But anytime they lose a matter, then the court is bad, the judge is wrong. But when they win, it is hallelujah. A year ago, they were holding press conference on the staircase of Parliament, praising the judiciary to the high heavens. Somebody went to court by midday. By 1:55 p.m., he had judgment from the Supreme Court.
What has changed?
Exactly. Suddenly, the judiciary is not fit for purpose. So this attempt to bastard these matters, they raised it by preliminary argument during the petition hearing at the High Court. They lost. They filed an interlocutory appeal. They abandoned it. Then they came back to trial. They went through the trial process. As we speak, they have filed 2 sets of notices of appeal and 2 sets of application on notice for stay of execution. Filed first by the original lawyer. Now they have filed a change of solicitor, and Gary Numaku himself has also brought similar applications. And then they followed it up with a certiorari application to the Supreme Court. So what they are doing is what we call in practice forum shopping. They are jumping from court to court, trying to file a plethora of court processes just so that Parliament's hand will be tied. But I can assure them, what they did to Jachi Kwesi in this country, Jachi Kwesi, what did he do?
So in this case, is it a tit for tat?
It's not about tit for tat, but it's about the law. In Jachi Kwesi, it wasn't even a final order of the court. It was an injunctive order of the court. A court in this country injuncted a sitting member of parliament. Before the final determination of the case, a court said that he cannot hold himself as an MP. He couldn't even go to his office. He didn't get access to his common fund. He couldn't come to parliament. When we went to parliament, they raised the issue and said he was not fit for purpose. He was no longer, he didn't have locus to be on the floor.
But would you say that Jachi Kwesi's case was a bit different because
it wasn't different?
Dual citizenship?
No, it wasn't different. It was about a member of parliament, the local standard of a member of parliament to be able to have standing at plenary. It's all about that. It's all about vacancy of seats. Whether or not a member is fit or eligible to be in parliament, whether he was properly elected at the time of his election. So whether it's by a petition or otherwise, whatever it was about determining whether the member was properly elected in law.
So in your understanding, would you still consider Nyindam at this moment as a member of parliament?
Nyindam is not a member of parliament. He is not. Until this court decision is torpedoed, set aside, or varied, Nyindam has no standing. And you should tell me one authority that says that when you file application for stay, now they are appealing to our emotions. Why? They are even lucky. Today, they have access to a court registry to file a notice of appeal and then follow it up with an application or notice for stay of execution. In Jachi Kwesi, when the judge delivered the judgment that took Jachi Kwesi out of parliament, we couldn't even file notice of appeal because the registry was not available. It wasn't working. We couldn't follow it up with an application for stay. We couldn't stay the judgment. The judge was switched to Kumasi with a motorcade. Look, things have happened. Today, they have access to the court. They do what they like. That is why they think that we don't know what we are about. But we know exactly what we are about. We like fairness. We give people the opportunity to have fair access to the system. They didn't give us that. If you like, call Eduji and find out from him what happened. Senior Maliba, ask them. We couldn't file a notice of appeal. We couldn't apply for application or notice for stay of execution of the court order.
If you see Nyindam in parliament from tomorrow onwards, what are you going to do?
I will not allow him.
Majority?
Me as the chief whip, I will not allow him. Because he was in parliament when Speaker ruled. Speaker said,
but you are not a law enforcement.
Hold on. I have a duty. I have a duty. I may not be the marshal, but I'll call marshals. You see, these things, you look, we are all capable. Don't think that you can come and show force in parliament. You were here, you were there when Speaker ruled. Speaker said, well, the matter that I raised was pretty premature. But the effect of the ruling of the court is that in pursuance of that order, you are no longer a member of parliament. But you are saved by the automaticity of 7-day stay of execution of the court order by virtue of the Court of Appeal rules provision. So for now, you have locus, but after Monday you don't.
In order
so,
not to, yeah.
So after yesterday, he had no locus. Today he wasn't in the house. We were ensured. Look, we also have a base that are putting fire. What they did to Jachikwesi, we will ensure that we follow precedent. He will stay in the house.
So in this case, you are confirming that this will be a tit for tat.
It's not a tit for tat. It's the law. We all went to court. They went to court
with the law.
They went to court. DS was not even on merits. It was an interlocutory application to bar Jachikwesi. They succeeded in getting the order. In that order, they implemented it to the letter. When we were pleading, in fact, I argued that once eventually we filed a stay of application, that is an interlocutory notice of appeal against the interlocutory grant of order. And then we proceeded to file application on notice for stay of execution. It should be sufficient enough. They said, no, that was bad law. I was talking bad law. And that there's no authority that says that when you file a process, it should automatically stay in the hands of the court. But
Mr. Afenyo, in this case, you knew that he had 7 days.
No, I admitted that I didn't avail my mind to it.
So why don't you wait for...
No, so the 7 days there's been a fluctuation of time. It's exhausted. So the decision was delivered.
There are two petitions currently in court.
The decision was delivered on the 24th of November. Today is 2nd of December. 7 days is gone. So you are saying that a certiorari application in the Supreme Court should stay in the hand. Now, let me also raise this.
100 days and per checks is about approximately 10 months. And many are not even aware that there were over 20 affidavits, counter affidavits, and supplementary affidavits that were actually filed in this instance. And by the time the main case was even heard, we're already in May and June. But, I mean, we have the ruling. And I want to start with you, Mr. Afenyo. I mean, you have seen the ruling. And in fact, based on the petition or the case that you sent to the High Court, your main focus was on the irregularities. I want to understand how significant, in your understanding, the irregularities were in terms of influencing the outcome of the Kpandai election.
Thank you very much. I would have loved you to play a couple of videos from the Kpandai Collation Center on the night of 7th of December, flowing into the early hours of the 8th of December. Absolutely unacceptable. Absolutely unacceptable. But you see, people are forgotten so soon. You know, between the 9th of December, I should say, until about the 30th of December, entering 1st January 2025, there were about 10 or 11 seats in contention, if you recall. Because I was placed in the center of it all to coordinate. So I have a very fertile understanding of the matters. We were contesting the outcome in Tema Central, Okainkwe Central, Okainkwe, I believe, Ablekumanov.
Yeah.
Domi Kwabenya. We're contesting the outcome in Obuasi East. We're contesting the outcome in Techiman South. We're contesting the outcome in Damongo. We're contesting the outcome in Kpandai. We're contesting the outcome in Akwitia.
That's more than 10.
Yes, Akwitia. Yeah. We're contesting the outcome in Suhum. We're contesting the outcome in Sawomadwajiri. We're contesting the outcome in, let me mention you, there was one more constituency in the north. So, you know, we had about 11 to 13 or 14 seats. So at a point, you remember that the EC had to be shifting collation centers from the constituency collation centers to regional collation centers. We were on TV, we were contesting the matters. We went to the High Court, we went to the Supreme Court, back to the High Court, all that. So eventually, 6th of January came. The life of that parliament had to come to an end. And so the Electoral Commission eventually had to put its house in order to submit names to Parliament for purposes of the 9th Parliament being given birth to. So in the morning of the 7th of January, or that dawn, before we were sworn in, there were a lot of issues. There were heated debates. And we told the NPP that some of the seats that you use executive power to take from us, for instance, that the ballot boxes...
You mean 2024, 2020?
Yeah, no, in 2024, that ballot boxes in Akwetia could be taken from Akwetia in a convoy with a motorcade and brought to Tesano Police Depot for results to be declared. We will use proper judicial means to reverse all those. So we went to court. Now, Kpandai is one of the cases. As we speak, Suhum is also in court, the Akuffo High Court. We are hoping that next week a decision will be delivered. People don't know, but we'll be quiet about it. We are in court in Tema Central. People don't know that we are in court. So, but this matter.
And in all of these cases, are you seeking for a rerun of particular polling stations?
We have placed our case before the court, and we have specific prayers, so that if the court finds favor with our evidence, that will lead and that will be recanted, and based on the probative value of the evidence and the law, if the court comes to the determination that a certain pronouncement be made in pursuance of PNDC law 284, that is the People's Representation Law, then there can only be 2 or 3 outcomes. The election can only be annulled, confirmed, or otherwise. So in Kpandai, now the case of the NPP in Kpandai is very, very interesting. On the 6th of January, they brought an application for, by way of a preliminary legal point, that the petition be dismissed.
I've seen a number of them, more than...
Yes, that the petition be, I have all of them here, that the petition be dismissed on certain stated grounds. That application failed. Now, eventually, the Electoral Commission, I've seen them brandishing some 24th December Gazette notification. But they have forgotten that the Electoral Commission put its house in order and eventually released a Monday, 6 January Gazette notification. This was the Gazette notification that we rely on in Kpandai. And they came to court brandishing the 24th December Gazette notification.
So if this is 6th of January 2025 and you filed your case in court
on the 25th.
25th,
yeah,
right?
We were in time.
So you were within...
We were within time.
What you're showing.
Well, we know our calculation. Our math is not that bad. So you see, by the 24th, the EC was not done with the other seats that were in contention. So they could not have released a comprehensive Gazette notification covering all the 276 seats at the time. So this was the Gazette notification containing all the seats in Parliament. So this is what we rely on in court. They brought the 24th December one. The court rejected it.
Based on what grounds?
Based on the ground that was not the final Gazette notification from the EC. The EC testified that this is their final Gazette notification.
So how many gazettes did the EC do before we arrive at this final one? Or this?
I am unable to say. But in any case, even if the EC released several Gazette notifications, the last in time will take precedence over all the previous. That is right. That is law. So the fact that they are still insisting that there's a certain 24th December Gazette notification, but they are concealing this material fact from everybody. That there's a 6th of January Gazette notification is what is very baffling to me.
Okay, I'll come back to you on that point, and I see you have a number of evidence and that you want to go through with us. But let me
political highway so a year NPP Kpandai a year MP and NCC say Parliament will be to NIC will be the time as court share 7 days and speaker so AD court and so after 7 days and a Parliament of course it's went to me and 29 and so into rerun of elections so live ebusia enye asam ketwa kra o ma file application to halt a court ruling but nyoma the one nyoma sibikeka kone de ebusia a court ne ruling ruling ya beda wase some je pene kokoti sa in some way edemai aha Ghana politics avenue so medamase